It's impossible in a limited time, and I want other colleagues to have an opportunity to contribute, to pay proper attention to every area of civil law affected by these proposals. So just a very few quick remarks on the areas that cause me greatest concern. In the issue of family law, no one disputes the value of mediation and the fact that cases which go to court, that the court action itself can have an extremely damaging impact upon families. Yet it is simply not always an option to rely on mediation. Not only are partners not always necessarily be prepared in both cases to go to mediation, but it does also imply that in those cases there is a willingness to compromise, and a compromise should be somewhere around the middle of the argument in an area of dispute over child welfare, maintenance and so forth, which simply ignores the fact that in many instances one partner or the other has behaved excessively badly or is making unrealistic demands, and indeed encourages them to make such demands. Good and powerful cases have been put forward by the Legal Aid Practitioners Association, and I will just read one into the record as an example. I am advising a client who is seeking contact with his children. The children's mother has remarried and has a new child with her husband. She seeks to marginalise our client from the children's lives, has denied contact, refuses to engage in mediation, and has moved to a secret address. The case requires a preliminary application to ascertain the child's whereabouts, and once identified, an application for contact. Clearly, mediation is impossible, and without early advice, the client will have absolutely no idea how to re-establish contact with his children. His options would be to try and find them through any means available to him, which would not be helpful, or to give up, which would deny the children the right to have a relationship with their father. With early advice, the application for disclosure would be made by solicitors, and once the children's whereabouts identified, a tactical attempt to negotiate and encourage mediation would take place. This particular client has some learning difficulties, and to navigate the court system as a litigant in person would almost certainly be impossible, and any attempts made would be hugely time-consuming. And another case, I am advising a client. He has 4 children and has shared residence for all of these and is very active in their lives. We have helped him in the past with residence issues with the benefit of legal aid. He is now facing an application by one of the mothers of the children to take his 14-year-old daughter to New Zealand, where the mother has a 2-year work contract. If this is allowed, from seeing his daughter half the week, he will be lucky to see her in the holidays and will not be able to afford airfares. In future, this client would have to deal with this form case on his own, which would lead to him giving up fighting the application. So we see, even in cases where domestic violence is not an issue, without legal aid, there are very real dangers that individuals, particularly those who have difficulty, say, with being sufficiently articulate or confident to navigate the court system, will lose access to their children.
Margaret James.
I thank the Honourable Lady for giving way. She makes a very powerful case this morning, but by mentioning that civil, family and social law are bearing the brunt of these proposed cuts, I do wonder whether she is going to comment, or whether the Shadow Minister will comment later, on where her party would have made the cuts had they been elected. As she mentioned, cuts would have been made if Labour had been re-elected. Now, the cuts proposed are less than 20%. If criminal law is to be protected, where would she or the Shadow Minister suggest that the government make these cuts that are perhaps, related to the speed and manner, which seems to be the main criticism? We'd like to see more detail, I think.
I have to tell the Honourable Lady that, and as I said in my opening remarks, the last Labour government had already made cuts to the legal aid budget, which were highly controversial, and there are many people in this gallery who were making fierce representations on that point. And I have already said that there were areas, particularly around high-cost criminal cases, where the government was intending to go further. I simply what ministers were also looking at was ways in which the civil and social welfare budget could be protected within the global legal aid budget, because it was absolutely understood that in many cases these savings in this area would lead to a false economy. I'm absolutely not going to be drawn into an argument about an equivalence of cuts and coming out with every figure, because I dispute the basis for what she's saying. Now, also, Mrs Rawdon, one of the areas that causes me greatest concern within these proposals is around the cuts to education. The government's intention is to take education out of scope, given the often unfulfilled statutory duty on local authorities to ensure that young people receive an education. This is bound to hit the most vulnerable the hardest. I am indebted to Just for Kids Law, which is a local specialist organisation in my constituency, for their information and assistance on a number of cases that I have referred to them. Last year, Just for Kids Law took 34 cases, with 2/3 having a satisfactory outcome. These are cases of children who are without a school place. They are cases where there is a serious dispute around children with statements or needing statements of special educational needs. And given that my borough, the latest figures, we have 364 children currently at this time in the school year without a school place, the need for representation for those parents is extremely clear. Again, a couple of very quick cases from their case load. These are cases that in future would receive no representation. E is a highly gifted boy who is on the autistic spectrum. His father was offered a job in New Zealand, so the family emigrated, and E started Year 7 there. Regrettably, there was no special educational needs provision for him, and he was so severely bullied that by August his parents had withdrawn him from school and made arrangements for the family to return to the UK. They had kept in regular contact with their local authority, but when they returned in January 2009, there was no place available. After 6 weeks at home with his mother, he was provided with a personal tutor for just 2 hours a week. His behaviour was rapidly deteriorated and he started self-harming. He told Just for Kids Law he wanted to go to school like everyone else and didn't want it to end up in a dead-end job. Just for Kids Law made representations to the local authority, and when this was unsuccessful, issued judicial review proceedings. After 2 mediation meetings with the local authority lawyers, he was eventually offered a place at a specialist autistic centre that integrates into a mainstream school. Without representation at every stage, there is a likelihood that that child would have ended up with no school place and no provision, with catastrophic consequences for him. R was permanently excluded from school in 2006. He has special educational needs and had been receiving specialised support for his behavioural problems. Successfully managed in reception in Years 1, but in Year 2 his behaviour worsened. Instead of referring him for an assessment for a statement of special educational needs or asking for the local authority's advice, the school permanently excluded him. The mother felt this was because her relationship with the head teacher had broken down. Just for Kids Law advised the mother at governing body appeal, which she lost. Just for Kids Law then appealed to the independent appeals panel and made representations that it was not lawful to exclude a child because of the breakdown in relationship between the head teacher and the mother. The school should have dealt with the problem by way of a managed move to another school that could meet his needs. The independent appeals panel agreed with Just for Kids Law's representation and overturn the permanent exclusion, which is no longer on the child's record. Again, a very, very vulnerable case, a very vulnerable family. We've referred previously to the issue of housing and homelessness. Now, it is the government's intention to retain provision for cases at risk of imminent homelessness, and yet, perversely, to take out of scope debt and other areas of financial advice, which are almost always the preliminary to a homelessness case.
Giving way. In Brighton and Hove, they're expecting a reduction of 80% in legal aid cases, down to just 280 cases per year. Whilst we all agree that we should be making some cuts, does the Honourable Lady agree with me that we need to carefully monitor that level of reduction?
Well, I absolutely agree. I'm extremely concerned about it, because what we are seeing now in other areas of public policy, the reductions in housing benefit expenditure, which are coming in next year, and indeed entitlement, we are seeing apparently a rise in the homelessness statistics. We are seeing major changes in housing policy, some just announced yesterday, which will lead to people being, homeless households being discharged into the private rented sector, with all of the risks that are associated with that. And yet, at the same time, the representation and advice available to people at the most critical stage in their path through the housing system is being removed. I am absolutely sure that the consequence of those changes in policy and a reduction in legal aid and representation will lead to some catastrophic consequences for highly vulnerable families, many including children with disabilities and special needs. I also predict that it will explode the budget of the Children Act on local authorities, where many of these cases will be referred, and once again it will be a false economy. Mrs Rodden, there are many other things I'd like to say. I'm going to conclude simply by referring back to this argument about the impact of these cuts upon providers. We have to start, of course, from the point of view of the client. The client is most important in this, not the provider. But if the client cannot access a provider, if there is an advice desert, if there is no one within 50 miles or 100 miles or a reasonable distance that people can afford to get to, then justice is denied to that person. And if services are removed, and the Honourable Gentleman, Member for New Forest, made a good example, if staff contracts are lost, if money is withdrawn on a piecemeal basis in the way that these proposals indicate from a law centre, from a firm, from Citizens Advice Bureau, then at a time when local authorities are facing record cuts in their expenditure, many of those services will go under. They will collapse in an unplanned basis. There will not be a coherent pattern of advice services because no one has overall control of making sure that, this happens. I will.
Mark Tammy.
Very much for giving way, and I apologise for my later tendency. I was having dreadful problems with my computer, which wouldn't work. But I've received an email from Flintshire CAB, who are very worried that they could lose the equivalent of 5 posts, totalling at some £117,000. And they deal with some of the most vulnerable people in our society, and quite often the same people that end up coming to see us. And they are very worried that this will have an absolutely devastating effect on the area.
I think that's absolutely right, Mr. Rudden. I'm going to sit down now to hear the examples from, I think, possibly both sides of the chamber. I urge the Minister to go away and ask his colleagues to think again about the way this is being implemented. The dangers are this will lead to advice deserts. It will lead to the refusal or reduced access to justice for many, indeed 500,000 cases of the most vulnerable people, and a real danger that it will lead to the perverse consequences of greater expenditure in many other areas of public service, and worse public services because they are not held to account efficiently by lawyers. So I hope that he will hear not only what I have to say, but what other colleagues have to say, and go back into the Department and ask for an urgent review of what the Government has brought forward. Yeah.